Welcome back, everyone. We are talking with my husband, Michael, about some asset protection planning tips that he has for folks as we are perhaps a bit jittery during these interesting times that we're facing.
Well, and really for these times or really any time.
Okay, so any time, but you know what? I think these times really wake people up to realize that they need to do something.
Yeah, that's absolutely true. Absolutely true. So, well, I was going through some basics here, a couple of thoughts. The first was to make sure you have that medical or that healthcare power of attorney in place, and some ways maybe you could do that where you're still keeping your social distancing and so forth. The second one is there's a companion power of attorney, and it's a financial one.
Interesting. Of course, our health and our finances, very, very big and important issues to everyone.
Right. So the companion to the medical or the healthcare power of attorney is, again, in most states, it's called a financial power of attorney or sometimes called a property power of attorney. I know Illinois used to use that term, which confused people because they think property means real estate, and they go, I didn't own any real estate. Why do I need one of these? And property is really in the more technical legal sense of the term, meaning essentially anything you own or anything you do financially.
Got it. And I don't want to take you off track, but there is another form out there, and I know we're not talking about that today, but that is also a living will. Not sure. I know that strays a little bit from our topic, but it's also something people might want to be paying attention to, correct or not?
Well, a living will is another medical document. It's sometimes used as a companion to the medical power of attorney. For folks that don't have anyone that could act for them under medical power of attorney, they could consider a living will. And essentially, it only covers one scenario, and that is you're hopelessly ill and you don't want to stay alive. It doesn't do anything for routine medical care, access to medical records. It doesn't involve anybody else. It's simply a directive to whoever your attending physician is at the time you find yourself in that predicament. So, although they were kind of the forerunner to the medical powers of attorney, they were very limited. Again, some folks do them as backup documents. There's no harm in doing one with a medical power of attorney so long as they don't conflict. The only other times people use them as a standalone is typically, again, they got no one.
Got it. Okay.
To be involved.
And that kind of goes along.
I'm sorry, go ahead.
I didn't mean to interrupt. That kind of goes along with the DNR.
DNR is a medical order that your doctor puts in. That's do not resuscitate. It may be reinforced by what you've said in your living will or power of attorney, where you say, look, if my heart or my respiration stop by natural causes, don't restart me. I don't want to be, resuscitated.
You don't want to be, yeah.
So that's, again, for people that are hopelessly ill and they don't want to be being brought back to life when in reality they want to die peacefully and naturally.
Got it. Okay. I just thought those documents might be kind of floating around and people might be wondering exactly how they're all connected.
What the heck is it that I have here? Yeah,
exactly.
In my little envelope in my safe deposit box, right?
Right.
And then so the one final comment on living will is it's the worst named document, I think, in the estate planning world because it gets confused all the time with living trust or with wills. Has nothing to do with your money.
I know. It really is confusing.
Yes, poorly named.
Yes.
But what we are transitioning to here in this segment is talking about the financial power of attorney or the property power, which does deal with your money. So it deals with everything from, yes, you can deal with real estate under a property or financial power of attorney, but you can pay bills, you can sign tax returns, you can execute documents, hire people to assist someone. So the financial power of attorney is, again, a very useful document to have in place if you do become ill, because it can help protect you and your assets from having no plan in place to deal with this situation. Because the alternative is if you don't have a plan in place to cover these two scenarios. If you're not competent to make decisions, you need to have a plan for who makes medical decisions for you. You need to have a plan for who makes financial decisions for you. Many people mistakenly think that, I've been married 30 and 40 years. Can't my wife or my husband just do this?
And what happens if they don't have any documents in place and they are married for 30 or 40 years? Can they just do this?
Well, the answer is it depends. Isn't that a very lawyerly-like answer?
It's that gray area, right?
It is. Some states, again, Illinois, I know for sure, does. With respect to medical care, they have usually some form of statute. I think Illinois is called the Healthcare Surrogate Act, where if you have no one named under a power of attorney and doctors say that you meet a certain condition, essentially you can't make decisions, that the statute then looks at a laundry list of people who would make decisions for you, typically starting with spouse or parent, if you're, a young adult, going on down through adult kids and other degrees of relationship, so that it does fill in the blanks, but it doesn't give a person guidance. It does not help if the person that might be top on the list is actually someone you don't want doing
Well, exactly.
that.
Yeah, I was just going to ask you that. What happens if it's somebody that you've been estranged from,
Right.
or situations like that?
You've got a child, maybe you're not married, but you've got a child and you're estranged from your child. Or what if you have 3 kids and 2 of them have one point of view about your medical care and the other one has an opposite one?
Right.
You're going to have disputes. So what happens when you don't plan, or if there's a dispute on the medical side, and if you don't plan on the financial side, is oftentimes you wind up going into court, so that, not you literally, because if you're the one, with the health issue, they're not wheeling you into the courtroom typically, but someone's going to go to court on your behalf to try to become appointed your guardian.
Right.
And a guardian can make medical decisions for you, make financial decisions for you, or make both.
And isn't this, I shouldn't say isn't it, but can it be a long, drawn-out process in the case of guardianship? Expensive as well.
It can be expensive because the court costs and the fees and so forth will come out of the estate of the alleged disabled or incompetent person. So you're paying for it typically. You have bonds that have to be put in place. We bond guardians so that they don't steal your money and run away somewhere to a country with no extradition treaty. And then we have to send Dog the Bounty Hunter after them.
Is he even still in business?
I don't know. That's a good question. And so we have to look at not only the expense, but you asked how long does it last? And the answer is until you die, unless you regain competency. So guardianships can be a really long-term situation. So you have to make sure with these planning, what you're doing is you're trying to avoid the guardianship court. So many people hear about, probate court is horrible. You want to avoid probate court. Probate court being the court where you go, where one goes to settle an estate when someone dies. The issue to me is, first of all, if your estate's in probate court, where are you?
Well, you're not here.
You're gone. You're in a different court. You may be being judged by somebody else at that point in time.
Exactly.
But it's not here in this realm.
Exactly. You're on the other side.
Exactly. So the issue with probate court is you're not here, and it's a finite period of time. It's going to end. Your state's going to get settled, and people are going to move on. It may be unpleasant. It may be expensive. But where are you if there's a guardianship going on?
Oh, you're still here.
You're still here. And it can go on, again, for years and years. So to me, of the two, if you say, I want to only avoid one of these two court systems, which do I pick?
I believe that would be guardianship.
Right. Oh, you're a quick learner.
Hey.
You're a quick learner. So we have a financial power of attorney. And that's my second tip. You got to make sure you have that medical power of attorney or healthcare one. Got to make sure you have that financial one. Now, most states are going to require it to be notarized. So you're going to have a little bit of maybe a social distancing issue if you haven't done it yet. You can still probably communicate with your lawyer over the phone and via digital methods to get this done. You have to be a little careful with these because if you put in the wrong powers, since you're giving someone access to control your assets, the wrong type of language can sometimes create tax issues. So you have to be a little bit more careful about this being a do-it-yourselfer kind of thing.
Well, and how often in practice did you used to fix do-it-yourself?
Yeah, unfortunately,
forms?
Too often. So let me real quick here go with a couple of other tips. Well, first of all, the third thing I think you can do is if you have a business, you have to consider doing a separate financial or property power for that business because that can raise a whole nother level of sophistication and issues.
Got that? Okay.
So mistakes. You want me to come up with, you mentioned mistakes and things people do wrong with them.
Right.
Okay,
right.
Let me give you quickly here because I know we're running out of time.
Yeah,
I see
we are.
From the engineer here waving at me.
We're bumping up against it.
Okay. So 4 things. First of all, don't surprise someone being your agent. Ask them, talk to them about it. Make sure they're comfortable doing it. Make sure you have more than one person named in some order of succession. You may say, oh, I want my wife or my husband to be my medical agent and my financial agent. Think longer than that. What if they're not around, they're not able, they can't do this? How do we make sure that we can have other people put these things in place, have successors? So you got to make sure you don't surprise people with doing this, that you ask them, that you make sure you have successors lined up in some order. Don't pick someone that is at conflict with other people in the family and think that, oh, this is okay, everything's going to work out fine. No, you don't need someone to teach others a lesson or anything like that.
Especially at your expense.
Exactly, because that's what will happen. It'll go into probably the court system, and it may be partially at your expense. And then finally, and I think I mentioned this earlier, if you have a business, don't be afraid to separate that out from your personal side because the level of sophistication may be in fact different.
Thank you so much.
Well, and I know we can't do calls to action on public radio, but I hope the listeners do consider making sure they have these powers of attorney in place with the right people on board.
Is it okay if I told listeners how to get a hold of you with any questions?
Sure. I mean, I can't give specific advice because I'm retired, but if they want resources or have similar questions, they can feel free to email me at michael@annbabiars.com.
Excellent.